Welcome to Future Epoch, where we learn more about our world. In 1999, an 18-year-old college dropout sitting in a Massachusetts dormitory built something that terrified one of the most powerful industries on Earth. He did not intend to start a revolution. He just wanted to find music more easily. Within 18 months, his creation had attracted 80 million users, triggered a legal battle that reached the United States federal courts, and permanently altered the relationship between artists, technology, and the people who consume creative work. The company was called Napster. Its rise was extraordinary. Its collapse was almost inevitable. To understand why Napster mattered, you need to understand the music industry of the late 1990s. The compact disc had transformed recorded music into one of the most profitable formats in history. By 1999, the global recorded music industry was generating revenues of around $40 billion annually. The major labels, Sony, Warner, EMI, Universal, and BMG, controlled distribution, manufacturing, and retail access. If you wanted music, you bought a physical disc. The internet was already changing that. Digital audio files, particularly the MP3 format, allowed music to be compressed, stored, and transmitted across computer networks at speeds that were becoming practical for ordinary users. The infrastructure for a revolution was already in place. Napster simply pulled the trigger. Sean Fanning dropped out of Northeastern University in 1999 at the age of 18. Alongside co-founder Sean Parker, he developed a peer-to-peer file-sharing application that allowed users to search for and download MP3 files directly from one another's computers. The system was decentralized in its transfers, but centralized in one critical respect. Napster maintained its own servers as a directory, indexing which files were available and where they could be found. Napster launched in June 1999. Growth was immediate and staggering. By early 2000, the service had accumulated tens of millions of users, many of them college students downloading music at high speeds over university internet connections. The numbers continued to climb. At its peak, Napster would claim approximately 80 million registered users worldwide, making it one of the fastest-growing services in the early history of the internet. The music industry responded quickly. In December 1999, the Recording Industry Association of America filed suit against Napster, alleging contributory and vicarious copyright infringement. Several major labels joined as plaintiffs. In April 2000, the heavy metal band Metallica filed their own lawsuit after discovering that an unreleased demo had spread across the platform without their consent. Dr. 12. Dre filed a separate action shortly afterward. Napster had become a legal battleground in less than a year of operation. The company argued that it was a neutral technology platform, that it did not itself copy or distribute music, and that it bore no legal responsibility for what its users chose to share among themselves. These arguments were not accepted. The legal case that would decide Napster's fate reached the United States Court of Appeals for the Ninth Circuit in 2001. The court's ruling, issued in February of that year, was methodical and damaging. The judges found that Napster had actual knowledge of specific infringing files on its network, had the technical ability to block access to those files, and had repeatedly failed to do so. This satisfied the legal standard for contributory infringement. The court further found that Napster financially benefited from the volume of infringing material on the platform and retained the supervisory ability to control it, satisfying the standard for vicarious infringement. The ruling dismantled Napster's core defense. The platform could not simply provide the directory, profit from the traffic it generated, and then claim ignorance of what was being traded through its servers. The court confirmed an injunction requiring Napster to prevent the sharing of any copyrighted material it had been notified about. Implementation proved impossible. Napster attempted to comply by filtering out copyrighted tracks using file name matching and other techniques, but the filtering was imperfect, easily circumvented, and wholly inadequate given the volume of material being shared. The labels argued, correctly, that the filters fell far short of what the court required. Judge Marilyn Hall Patel, presiding at the district court level, ruled in July 2001 that Napster must remain offline until it could guarantee that no copyrighted material would pass through its network. In practical terms, this meant the service was finished. Napster had failed not because its technology was flawed, but because its entire business model rested on content it did not own and had no right to distribute. It had grown faster than any licensing agreement could be arranged, and it had done so by offering something the established industry was unwilling to provide on its own terms. Napster filed for Chapter 11 bankruptcy protection in June 2002. Its assets were eventually acquired by Roxio for approximately $5 million, a figure that illustrated how completely the company's value had been destroyed by the litigation. The Napster brand changed hands several more times over the following years, before being absorbed into streaming services that had no connection to the original platform or the people who built it. The legal precedents established by A&M Records v. Napster did not stop file sharing. Within years of the ruling, decentralized networks such as Kazaa, LimeWire, and BitTorrent had emerged and spread. These systems lacked the centralized directory that had made Napster legally vulnerable, and they proved far more difficult to prosecute. The industry would spend the better part of a decade pursuing individual users through the courts in a strategy that generated enormous public controversy and accomplished very little. The more significant consequence was not legal but commercial. Napster had demonstrated, beyond any reasonable doubt, that enormous consumer demand existed for digital music delivered on demand at any time without leaving home. The industry's initial response was litigation rather than adaptation. It was not until Apple launched the iTunes Music Store in April 2003 that a major commercial actor offered a legitimate, convenient alternative at a price point consumers would accept, selling individual tracks for 99 cents each. The streaming era came later still. Spotify launched in 2008 and spent years negotiating licensing deals with the same labels that had sued Napster out of existence. Today, the recorded music industry earns more than half of its total revenues from streaming subscriptions and advertising. The consumer behavior that Napster revealed in 1999 did not disappear when the service was ordered offline. It simply waited to be served through a legal channel. The story of Napster is not simply a story about copyright law or corporate self-interest. It is a story about the gap that opens when technology makes something possible that established industries are not yet willing to provide. When that gap is wide enough and the demand is strong enough, users will fill it themselves, legally or otherwise. Napster also revealed something about scale and legal exposure that remains relevant to every technology platform that has followed. Growing to 80 million users without a licensing agreement, a revenue model, or a working legal framework was not a sign of momentum. It was a liability accumulating faster than anyone could contain. The quicker a platform scales on content it does not control, the more catastrophic the eventual reckoning tends to be. Sean Fanning was 18 years old when he built Napster. He was 21 when a federal court ordered it offline. In the years that followed, the music industry eventually offered consumers something close to what Napster had provided, through platforms that paid licensing fees and negotiated rights and operated within the law. The services that now stream billions of songs every day are the legitimate descendants of the same fundamental idea. The question that Napster raises, and that has never been fully resolved, is whether the commercial and legal systems that govern creative industries can move quickly enough to meet the pace of technological change. When they cannot, the gap tends to be filled by something that operates outside the established rules. Sometimes those things collapse under their own legal weight. Sometimes they become the foundation of the next era. Napster collapsed, but the world it imagined did not. Thank you for watching. If you've enjoyed this content and want to see more, please consider liking the video and subscribing to the channel.